Today at Investigate TV Plus weekend, when a loved one dies, their family can't just grieve, they have to lawyer up. We investigate the complex court process required in all 50 states to unlock what's left behind.
We need to grieve properly, and we cannot grieve properly if these things are not worked out.
Plus, some call it a free kill law, why some families are blocked from suing for pain and suffering after a medical death in one of the country's most visited states.
This patient is no longer here because the standard of care was not followed and it cost their life. You have no accountability.
Investigate TV Plus weekend starts right now. Hello and welcome to Investigate TV Plus weekend. I'm Lee Zurich. It's a taboo topic most people avoid, but none of us escape. Death is certain for everyone, but our team found few Americans take steps to prepare for it. Roughly 30% of Americans have a will, and even fewer realize just how complex and expensive it is to die. Loved ones are often forced to navigate a clunky court process called probate while they grieve. Our Chris Nakamoto hears from families left confused from coast to coast and why some attorneys say Congress must act to simplify the court process.
This is a picture of my dad and his siblings, probably one of their last family pictures. And I'm curious what they were all gathered for, since they all are dressed up clearly.
As Joe Miller gazes at old pictures of his father, Terry,
this is a really old family picture. I would have been in high school, I think, at the time.
These snapshots in time are now his most cherished memories.
I feel like that character shaped who we are, and there are times that I find him showing up in something I do or the way I approach something.
On June 26, 2021, Terry Miller died of complications from a urinary tract infection at the age of 73. As grief set in, Miller found comfort knowing his dad, who worked as a truck driver and lived a modest middle-class lifestyle, was a planner.
I thought, and my brothers thought, we thought, okay, well, once we find the will, this can all be sorted out. I knew that he had made my brother the executor of his estate because my brother and I had talked about that. We had had a conversation about that.
But despite having a will, everything his dad owned was off limits, as it took a long time to validate that document.
It was just kind of this chaotic thing where you're trying to process your dad's death, and at the same time, you know that there are details that just need to be worked out.
4 long years later, Miller's sadness over his dad's death swiftly spiraled into madness. Grief put on the back burner as his siblings continued to navigate a complex court process called probate. More than 4 years after his dad's death, the family still can't access everything he owned. At the moment Terry took his last breath, nearly all assets and bank accounts in his father's name were frozen. For example, this house that Terry called home in Lebanon, Missouri, still tangled up in court proceedings.
Grieving is very important. It's part of who we are, it's part of being human, and we need to grieve properly. And we cannot grieve properly if these things are not worked out.
I am the owner and proprietor of my law firm. We do nothing but estate planning and administration in Louisiana.
Laura Poche is an estate planning attorney who understands Miller's frustration. She spent her decades-long career navigating this debacle over death for clients.
When somebody dies, this is the way I explain it to my clients, it's almost as if an imaginary camera takes a picture of any property titled in the name of that person's name at the moment of death. So upon my death, if real estate is titled in my name, if a bank account is titled in my name, if a brokerage account is titled in my name, Louisiana law, and most laws in the other states, has always required that a court process, a judge, oversee the distribution of those types of assets after death.
Unless you already have an estate plan, which includes a trust, our national investigative team found probate is required in all states in America upon death. In Louisiana, that same process is called a succession. That process involves hiring a lawyer and in many cases a lengthy court process. Probate is the Latin word for prove, with the first probate hearings over land and wills being held in the 1700s in Massachusetts. Over the years, probate lawyers say the process has become lengthier and more complex. Our national investigative team found families caught off guard and confused from coast to coast.
So if you own real estate, mineral interests, REITs, timeshares, stocks, bonds, mutual funds, CDs, U.S. savings bonds, checking and savings accounts, titled vehicles, aircraft, watercraft, not to mention LLCs, corporations, partnerships, sole proprietorships, all of these types of assets, these are what we call probate assets.
Poche says even if you have a will, those assets can't be released until probate is complete. That's because in recent years, scams have become prevalent, and she says banks have become skeptical of releasing funds until they have a final judgment from the courts. Without that document, a deceased person's assets are off limits.
Effectively, these internal policies have been changed to protect these banks against liability in the screwy world that we're living in today, okay?
This woman, who we will call Jane, did not want her identity revealed over issues she discovered after her beloved mother-in-law, affectionately nicknamed Skeeter, passed away.
She was a very special lady. She loved her family, and my husband in particular, that was her baby boy.
Skeeter's death last fall was no surprise. After living life to the ripe age of 100, Skeeter had taken steps to make sure her family wouldn't bear a burden upon her death. But Jane recalls her family getting caught off guard when the probate process began. Everything Skeeter owned turned into a public record for everyone to see.
You know, just as we try to keep ourselves, our things private in our life, that it should not be public record in our death.
This is a recently filed probate document. We found it available online. It's a glaring example of what Jane is talking about and how much personal information is available. We're not identifying the individual in this example to protect the family going through the process, and we've blurred sensitive information you would never share with people you don't know. But take a look at this. You can see their Chase checking account numbers and the balance in each of their checking and savings accounts at the time of their death. All of their investments, accounts with Merrill Lynch and Centura Advisors, with the complete account numbers and the total amounts, even the VIN number on the Mercedes sedan this family drove and the value of the vehicle. These public probate documents also show how much debt the individual owed creditors, all things that could be useful to scammers for anyone to pull and see.
Now, you can be in China and you can, get on the computer and you can see every single probate, what all the assets are down to the penny and where they're at, the banks, where they're located. Not only that, but you're gonna know who's getting what and the exact amount that they're getting and when they're getting it. So imagine that.
Craig Parker is a trust and probate lawyer in California with over 20 years of experience. He believes the probate process needs an overhaul and would like to see Congress step in, starting with protecting the privacy of individuals who die across America. He also thinks the clunky process needs to be simplified.
Most people, like you said, I would say the majority of people just have no idea until it happens to them. The odd thing is all of us are going to pass away. And so it's not that it's an uncommon or something you can avoid. So it's going to happen to everyone.
Our national investigative team reached out to leading probate lawyers in all 50 states and scoured all state probate regulations. Our team found where you live and the assets you possess will determine the amount of time and money you can expect to spend on this process. In about half of the states, we found probate can take about 6 months to a year on the short end. The other half could take 9 months to 2 years or longer. In states like North Carolina, the average processing time for a straightforward probate could take 7 to 12 months and cost a minimum of 2% of the estate's value, but that figure can go up to 8%. Arkansas also follows a percentage system for probate costs. In Iowa, it can take 6 to 12 months and cost between 1 to 4% of the estate's value. In California, the probate process is lengthy and expensive. A middle-class estate can cost $7,000 and take several years. Other factors that contribute to the delay: how many assets are involved, how busy the courts are, and whether there are feuds between family members.
Even more so, if you have a small estate, think about how stressful it's going to be on people to try to pay the bills, deal with the grief and all of that that's going on.
Attorneys say the biggest issue for their middle-class clients is the sticker shock they face. having to shoulder the expenses until there's a final judgment. For people like Miller and Jane, death taught them a life lesson.
To me, do your family a favor and have all this stuff sorted out. Because the last thing your family needs to be doing is going through this crazy legal process instead of grieving your loss and grieving your death.
Both lawyers we talk to say there is a mechanism for Americans to avoid probate. That includes starting an estate plan now and setting up a revocable living trust. While some lawyers say that's not necessary for smaller estates, it is one way for Americans to avoid the probate process.
Coming up, he served his country, but his daughter says the law failed his family when it mattered most. In most cases, if a loved one dies from medical malpractice, families have the power to sue. But that's not always the case in one of the most visited states in the country. Florida's Wrongful Death Act says that if certain people with no spouses and no children die from medical malpractice, their family can't sue for pain and suffering. Only economic damages like funeral expenses and lost earnings. Our Kristen Crowley traveled across the state to hear both sides of this controversial law and its impact on anyone living or traveling to the Sunshine State.
Just looking at Taylor Jenkins.
She was just living her best life, pouring love into other people. She was such a ray of sunshine.
And Keith Davis.
My dad was an old soul, and he loved to play the acoustic guitar. He loved animals.
You may not see they have much in common. Taylor was 25, a flight attendant. Keith, 62, a Navy veteran. But their loved ones say they share a devastating bond of injustice.
You had no idea this law existed?
I had no idea, and I work in healthcare.
It still hurts really bad.
In 2020, Sabrina Davis's father died from an undiagnosed blood clot in his leg. His death ruled a result of medical malpractice. 3 years later, Taylor, who was in a car crash, died from internal bleeding. Her mother, Cindy, received a sworn statement from a medical expert saying her death was also a result of medical malpractice.
In reviewing her record, I know that she had laid there in that bed losing blood for 15 and a half hours because the torn artery went undiagnosed for so long.
But Sabrina and Cindy say neither of them could get justice because in Florida, the law doesn't allow it. This is that law. A portion of Florida's Wrongful Death Act, passed in 1990, allows families to only sue for economic damages in medical malpractice deaths, which can include lost wages and funeral expenses. But it bars lawsuits for non-economic damages like pain and suffering if the victim has no children under the age of 25, isn't married, and is 25 years old or older. Cindy's daughter and Sabrina's father both fall into that category. It has earned the name from critics, free kill.
You are getting a free pass, which is why we say free kill. This patient is no longer here because the standard of care was not followed and it cost their life. You have no accountability. You got a free pass. This was a free kill.
Why are the damages for pain and suffering so important to families?
When an attorney can only recover for economic damages, they can't afford to take the case.
Meaning families can't go to court and can't hold doctors accountable.
If they cut off the wrong leg, you can sue. If they cut off the wrong leg and let you bleed to death and die, you cannot sue.
Jed Kurzban is a medical malpractice attorney and one of nearly a dozen attorneys Cindy contacted for help.
So this was Mother's Day 2022.
Every one of them gave her the same answer. We can't.
This law must be changed. It is truly a travesty.
Does this law only affect Floridians?
No, it affects anyone who's been malpracticed on in Florida. I get those calls every week. We came to Disney, we took a cruise out of Tampa, we took a cruise out of Miami. This thing happened, what can we do? In Florida, nothing.
So how did a law that doesn't exist in any other state across the country pass in the first place? Legal experts told us it was to keep medical malpractice insurance premiums low so doctors wouldn't leave the state. Cindy says there's a better fix for that.
You want to lower malpractice premiums? Stop the malpractice.
Good afternoon. The Committee on Judiciary will now come to order.
The fight to change the law has ramped up in recent years in Florida's capital city.
To me, it comes down to fundamental value of life. It should not matter someone's age, the age of their children, their marital status.
State Senator Clay Yarborough has signed on to multiple bills to undo the law. None has passed. He says one reason is concern lawsuits will skyrocket.
Do I want to see more lawsuits? Absolutely not. But do I want to make sure we maintain accountability? Absolutely.
Even still, he doesn't think an outright repeal will pass, which is why he sponsored a bill with caps, a limit to how much money families can collect.
I think Senator Yarborough has come up with really what I call a grand bargain. Those individuals would now be able to bring this lawsuit.
William Large with the Florida Justice Reform Institute is a former medical malpractice defense attorney and worries repealing the law would be a financial disaster for doctors, hospitals, and insurers.
What about other states in the country that don't have laws like this?
Several states have caps on non-economic damages.
26 states have caps for medical malpractice, ranging as high as $2.25 million in Nebraska and as low as $250,000 in California. Illinois was among this list until 2010, when the caps were deemed unconstitutional. The effect of losing them? The Illinois Trial Lawyers Association told us medical malpractice cases actually dropped 5%.
This is his dog tag from the Navy.
And some families say while they want the law changed, adding caps is not a move they can support.
In my heart, I know that no one can put a price on my dad's life.
I would give everything I own. They could drop me off on a street corner and take everything from me, and I would let them do it if I could have my daughter back.
Our interviews with experts and families about this law started in January, to the surprise of many of them. On May 1st,
33 yeas, 4 nays, Mr. President.
So the bill passes.
Legislators approved a full repeal of the law, no caps. Cindy and Sabrina were thrilled until.
That's going to lead to a flood of lawsuits against practitioners and against hospitals.
Florida Governor Ron DeSantis announced he would veto the bill, marking an end to this battle.
Here is my daughter in a box on my dining room table.
But families say it is not the end of their fight.
My dad was willing to give his life for this country and for our freedom, and it may not have happened on the battlefield. It may not have happened in a submarine, but it happened. I feel like it's the least that I can do to keep fighting.
Up next, she left her abuser and disappeared, but he still knew her every move. How a legal loophole put her life in danger and sparked a first-of-its-kind law. Imagine a stalker knows your every move and you have no idea how. That's exactly what happened to one Louisiana woman whose story has inspired a new law in the state, the first of its kind in the country. Reporter Liam Combs in Baton Rouge uncovers the loophole that allowed her ex to know exactly where she was, even when he was states away.
Christine Dowdall had a stalker. Not someone hiding in the bushes, but an ex-husband tracking her every movement.
It steals your soul. Absolutely steals your soul. And you'll never understand it until you go through it.
After multiple protective orders against her abuser, she was still being tracked with no idea how.
I'm over here in Dallas because we're from Bossier City, and he knows I'm over here. How does he know exactly where I'm at?
Until this message popped up on her car's GPS system.
Oh my God, that's it. That's gotta be it. Because I'd never seen that before.
It turns out after the divorce, her ex's phone was still connected to the car's GPS system. Search warrants later uncovered that he would track Christine's movements up to 20 times a day. And later on, when authorities asked the car company to shut him out of the system, they refused to comply.
Mercedes at one point told me, he said, well, why don't you just ask him to uninstall the app?
Well, we already had judge's orders telling him not to do things. At that point, she had also had sole and exclusive use awarded through the divorce proceedings. But their response was, ask him to uninstall the app.
Yes, sir.
But that all changes with House Bill 74, signed into law by Governor Jeff Landry, now holding these car manufacturers liable if they do not comply with protective orders. It's a first in the country.
Where finally we have a law in place that recognizes that tool and how abusers are using technology to establish and to maintain that power and control over their victims.
For Christine, she hopes her story and this new law inspires other states to also take action.
After the break, want a better credit score without the guesswork. We share 2 simple moves that could boost your number and financial future. Your credit score can open doors or slam them shut. It affects loans, rentals, even job opportunities. In this week's Watching Your Wallet, our Rachel DePompa breaks down the simple steps and common mistakes that could make or break your credit score.
Your credit score is directly tied to your ability to build wealth. We're talking interest rates, what we qualify for, the loans that we have access to. It's so very important to not only build but maintain good credit. To help us today, I caught up with Kiani Epps. She's a financial educator from the popular website and YouTube channel, The Responsible Home Girl.
The first thing I would recommend is paying your bills on time every month. Our payment history makes up about 35% of our credit score, which is huge. So if you find yourself in a situation where you can't necessarily pay your bills on time, I need you to pick up the phone, talk to that service provider, communicate with them, let them know what you have going on, because there's always something that they can do.
The second thing she recommends is lowering your utilization, which is how much of your total available credit you are using.
The recommendation is to keep your credit cards underneath 30%. So say for instance, you have a credit card and your limit is $1,000. I want you to keep your utilization, aka how much you use, your balance, beneath $300. But if you're on the other side of this and you have a credit card and it's beyond that 30% or is close to being maxed out, it's okay. Just work to pay it down.
The last small thing she recommends is just to check your credit report and make sure there are no mistakes that are hurting your score. You can get a free credit report just by going to annualcreditreport.com.
And that's it for us. Thanks for joining us here on Investigate TV Plus Weekend.